Hi guys. Hi guys. I'm Shivankar, and I am here taking this webinar on the insolvency and bankruptcy code, specifically as of day in India, and generally as to what the history of the legislation has been so far, and where we can possibly see this go in the future. So, in terms of the layout of the presentation as such, this is just a primer in the sense of an introduction towards what it is. And it's not a very detailed examination because I received a couple of questions as to what exactly are we dealing with here and how advanced is it. So this is just basic stuff which any law student should know, any lawyer who's recently graduated should know, and anyone who needs to have a commercial sense and idea of the law should have an idea about. Now, the importance of this field is judged as in if you may be any kind of lawyer, you still need to have a knowledge of this field. It's important for a commercial or a corporate lawyer because you need to put a lot of clauses in your drafts when you're drafting it. It's important for a litigation lawyer because there's a whole field of law which surrounds it, in which it is actually practiced in the NCLT and NCLAT. And it is, I would say, even important for people who are not lawyers. It's important for an economist. It's important for anyone who wants to be aware of how credit is actually flowing in the country and how it flows. So any economist, anyone who has a general kind of financial inclination, this is a field which everyone should be aware of. Now, historically, and this is what we do in corporate firms mostly, we study how to put in money, we study how to exchange money, we study share purchase agreements, we study share subscription agreements, we kind of draft them. So in detail, we have looked at how FDI flows into the country. So it's very easy for money to come in a way. It's very easy for money to trickle down from a holding company to a subsidiary, for the money to come from US, from Mauritius to India. But as easy it is for it to come in under the current state of law, it is equally difficult for it to be taken out. Now, the Bankruptcy Legal Law Reform Committee gives it that India has an average rate of about 4.5 years to take out credit for a company or to dissolve a company totally. So you can imagine, compared to 8 months in Singapore, compared to 1 year in the US, or about 2 years, sorry, 1 year in the UK and 2 years in the US, 4.5 years is a lot of time. Now, why do I say time is such an important factor in our examination over here? Because time leads to erosion, and erosion is something that, basically, think of it as rust. If you allow iron to stay outside and get oxidized slowly with time, it will rust away. Similarly, if you leave a company and you let it erode over 4 years, the joints will rust away. So it's very important to preserve the company and to kind of deal with it in whatever way possible in an immediate sense. So timing is of utmost importance. Okay, so that was for a short introduction. Let me just get into the actual kind of presentation and what I'll be dealing with. So I plan to kind of deal with it in 3 segments. The first will be the historical perspective, where I will just look at what the position of the law has been historically since about independence. I'm doing an analysis of about 85 to 2000s. Uh, what the law exists, how it exists in the books today. So what is the code? What does it actually say? How did the code come about? And any future development where we can possibly see the law go. And I think the third segment is the most important, because as lawyers, as litigators, as corporate kind of future corporate counsels, we're too engrossed in the middle section, which is the law and books, without having enough thought about how the law should develop. And I say this acutely aware of the fact that the law as it exists in books has a lot of lacunas, it has a lot of vacuum. There's a lot of open questions subject to interpretation, which we have to fill in. So we can either fill it in having a backward look in the sense of how historically we have been doing things, or we can fill it in with a more guiding light as to how we should do things. And this is where I kind of follow the more futuristic vision as to the development of the law and how it should develop, how the gaps should be filled, which is the third segment I will be dealing with here. So the study of insolvency law as such, it's very hard for me to kind of summarize in 45 minutes or so, the time I've been given here. The study itself is a 4 credit course, which has different segments, which has different parts. So it can be kind of studied over a whole semester, but I'm going to just summarize the main position of the law for you, and as to how we should probably study it in a capsule form. Now, one of the earliest legislations which deals with one's personal bankruptcy, this is an individual that I'm talking of here, is the Provincial Insolvency Act of 1920. We are sitting currently in 2020. So as of date, personal bankruptcy, because the new provisions have not been activated under DRT and DRAT. So as still as of date, the individual, if he needs to kind of declare his individual bankruptcy, he needs to do it under 100-year-old legislation. So one can imagine how the law in this count has failed absolutely and absolutely disappointed the society so as to keep pace with it. Uh, However, our legislators were a little more active on the corporate side of things, and they did come out with a couple of legislations on how to deal with monies which are owed by banks from companies. So one of the first laws that came about in 1985 was SICA, or the Sikh Industrial Companies Act, I'm sorry. Now, SICA had a very easy trigger. The only trigger in SICA to kind of get a company inside a courtroom was, do the accumulated losses far outweigh the net worth? And that's a very simple exercise. If you are aware of your balance sheet, uh, you can quickly calculate it. You can quickly calculate the loss. You can look at the net worth of the company, and then you can do a quick mathematical comparison whether the losses far outweigh the net worth. Now, I say this because most of the startups we know which exist in the country today, you will find that actually they have long gestation periods. So in a way, their accumulated losses far outweigh the net worth for maybe 10 years, 15 years, for a really long time. So this is a very outdated approach to determine whether a company will survive just by doing a comparison. Secondly, it's also very easy to manipulate accounts. Since it's an automatic trigger, there is no active involvement required, and it's just kind of a numerical exercise. It's very easy to kind of just manipulate these balance sheet figures and say that that's not the case. Now, in the event a company was admitted under the BIFR, Board for Financial Reconstruction, that was the name of the court, a specialized court in which you could take to a company. They would have an inquiry, they would have a report, and then they would have certain remedies that could be looked at. One was winding up. The second was the board giving more time to the company to kind of put its house in order. And then they had some other less used remedies such as reconstruction, sale lease, and change in management. However, all in all, it wasn't a very successful act, which is why, I'm sorry, which is why just 8 years later, the legislators decided to come out with the second act, which is the Recovery of Debts Due to Banks and Financial Institutions Act, or the RDDBFI, as I like to refer to it. Now, the RDDBFI led to the establishment of, I would say, the first level of tribunals in the country, the DRTs and the DRATs. Now, these, as of date, are about 33 debt recovery tribunals, and there are about 5 DRAT tribunals in the country, spread all over. Now, the trigger under the RDDBFI Act was that if a bank is owed 10 lakhs or more, or a financial institution or a bank, they can then drag the company into the DRT. Now, the problem with this is, firstly, you're only limiting in scope to organizations such as banks, and banks are very big organizations in the country. It's very difficult to achieve a banking license from under the Banking Regulation Act. And these are like, think of all the major banks: Kotak Mahindra, HDFC, Yes Bank, ICICI. So these are too far and too few in between. So it was in a way catering to only the big boys, and not kind of, let's say, a middle-sized NBFC or even something smaller like a private equity. So this was obviously, it was back in 1993, so we couldn't even think of catering to these organizations. So firstly, it was very limited in its scope. But an interesting thing to do with the Recovery of Debts Due to Banks and Financial Institution Act was that it introduced a concept of set-off and counterclaim. Now, what exactly is set-off and counterclaims? It basically means that if I am a bank and if I give you money, at a later stage, you can also claim certain money against me, in the sense you don't owe me money, but I owe you further money after the dispersal has happened. Uh, to simplify it, it's like our cross debts will cancel each other out and no one owes anything to each other. So this is a very unique concept which they introduced. As of day, BRTs are the only place where you can claim set off. Under the Insolvency and Bankruptcy Code, there is no provision for set off. And then they had the regular kind of reliefs in terms of appointment of receiver, in terms of appointing a person as a custodian, and and different reliefs they still have. Now these reliefs are pretty standard. If you had attended Abhilaksh's lecture yesterday, he spoke about execution, attachment of property. So these are fairly regular kind of reliefs and remedies under the Civil Procedure Code. Nothing too radical about these reliefs. But strangely enough, in order to appeal against a DRT order, you had to deposit 75% of the amount which you were ordered to pay. Only then could you go to a DRAT. In theory, there was no appeal from a DRAT, but the high courts after a point started entertaining a lot of writ petitions under Article 226 and 227, which led to a plethora of case laws everywhere. The banks were suing the creditors, the banks were suing the debtors under the DRT. The debtors were counterclaiming against the banks in DRTs. These were going to DRATs. There was high court action involved. It was basically quite a cluster of litigation which was happening. It was quite a mixed soup, so as to say. Now, the third act, which was the most important and which was very much in vogue before the Insolvency and Bankruptcy Act, was the securitization and reconstruction of financial assets and enforcement of security interest, for short, SARFAESI. Now, some of you may have studied about SARFAESI in law school. SARFAESI was a very simple act. However, it did a lot of things which were not that simple. First of all, it provided for the establishment of asset reconstruction companies. Now, these ARCs are essentially financial companies. This is regulated by the RBI. Their jobs is to basically take your loans, or let's say we have a company called HDFC, which is in the business of mortgage loans. HDFC can take its pool of loans and further resell them to one of these ARCs. These ARCs will then create tranches, issue security receipts, and further pass the risk. What this ends up doing is you never have the loans on your books, but you repackage the loan and you pass it on to the next guy along with the risk. So when the money comes to you, in the sense of when an EMI comes to you, you take your cut and you pass the rest of the money. This is a way in which a lot of reselling of loans, mortgages, and other kind of credit instruments happen. And it's been happening in the US. If you remember, in 2008, the subprime loan crisis in 2008 was an effect of a securitization failure in the US mortgage market. But this was thought of as a novel way of letting banks, pass the interest to some other third parties. It was, from what I understand, it wasn't very successful. It was successful to some extent, but not very successful. Secondly, what it did was reconstruction of financial assets. It's basically your reconfiguration of payment terms. And thirdly, the most importantly, was the enforcement of security interest. Now, this is a very simple concept. In a way, if I am a bank and if I have a security against an individual or a company, I can enforce that security without going to court. This was probably the most groundbreaking, well, discoveries in banking laws, that you don't even have to go to court to enforce the security. I, as the banker, just need to give you a 60-day notice, pursuant to which I can take over the security, I can take possession, I can take control over it, I can take control over your business, and I can just generally assume charge. To that extent, Section 14 actually provides that I can even take the assistance of the subdivisional magistrate in order to enforce my rights. The trigger for all of these actions is that you should be an NPA, which is a non-performing asset. Now, exactly what an NPA is, I don't want to get to this stage. RBI has a detailed circular on what an NPA standard asset and a substandard asset is. But if you're an NPA, I give you a 60-day notice, you don't pay me back, I take over your business. Assuming it's not agriculture land, because this was kept outside the purview. Now, this was very unique because you're putting a bank in charge of a business. Now, a bank is in the business of borrowing and lending money. suddenly if you take a bank and you kind of give it a business to run, I'm not sure as to how successful it may be in doing that. And eventually a lot of bankers found themselves on the boards of these companies where they had to take commercial decisions, where they don't have any knowledge about running a company, but yet the law provides that they are in the driver's seat. So I'm sure a lot of public sector banks were surprised in that sense, but they managed pretty good. Uh, if you look at, there was at least a 68-70% recovery rate under SARFAESI, which was only about 28-30 under the RDDB FIs. So to a large extent, it was a successful legislation. It's just that the way it enacted, the way it was done, was possibly not how we run corporations in today's enterprising world. Now, this concept of security interest was defined under the SARFAESI Act. It's basically an encumbrance. As to what it is, I will just deal with it in some time. Uh, Now, all these acts were followed by the constitution of the BLRC, the Bankruptcy Law Reform Committee. Essentially, the committee was a bunch of really smart economists, lawyers, financiers, industry experts, law firm partners, and just who's who of the corporate world, who sat down and who was given this task by the government to kind of look into this and kind of have upheaval the law and suggest an absolute radical new paradigm. So they came out with two reports. One was one was in June, July, which was the interim report, followed by the final report, which came out in November of 2015. Now, the skeletal structure of the insolvency was actually presented by them in that very report. And this report was ultimately then sent to a joint parliamentary committee where further changes were made to it, pursuant to which it was passed by both the lower house and the upper house, and it was enforced from 1st December 2016, December of 2016 essentially. Now, before I get into the act as such, there's a couple of conceptual concepts I would just quickly want to discuss. Now, in banking law, it looks like a very difficult field to navigate. However, it's fairly simple if you have a couple of things in place, your fundamentals. Now, by what I mean the fundamental is the security interest. Now, MCLP is how I do it. It's mortgage, charge, lien, pledge. The different kinds of security which you can give in return for money is essentially an encumbrance, a security interest. Different legislations define it differently. Now, what exactly is a mortgage? For the students of transfer of property, mortgage has been kind of dealt with in great detail under Transfer of Property Act, Section 58. You have simple mortgage, you have mortgage by conditional sale, usufructory, you have the English law mortgage, and the equitable mortgage, which is also called the mortgage by deposit of title deeds. All in all, mortgage means you have an immovable property and you transfer an interest in the immovable property. So an immovable property, you transfer an interest, mortgage. Which kind can be depends, it's as per the give and take. Secondly is the concept of charge. Now, charge is how we understand on a movable property. So this is what differentiates the biggest differentiation under a mortgage and a charge is one is over immovable, charge is over a movable property. However, the title and the interest and the possession lies with the borrower. So I merely just give you let's say the paperwork, or I will give you the documents, but the possession and my title still remains with me. So anytime such a thing happens, it's basically a charge. Now, charges are of, let's say, floating charges. You have a floating charge which is not fixed on anything, and which kind of only crystallizes at a later stage. And you have different other kinds of charges. Hypothecation is also a kind of charge. Hypothecation has been defined under SARFAESI. The way most of us know hypothecation is hypothecation of our vehicles. Where every time we take a loan from a bank, we actually hypothecate our vehicle. However, we never give the actual car to the bank. We just give them a copy of the ownership papers. So that's a very good way of understanding charge is basically movable property possession with me. Now, a pledge is quite the opposite. A pledge is a movable property, but the possession is with the banker or the creditor. Now, pledge is mostly used for shares, both in demat and physical forms. You pledge your gold instruments or your gold jewelry. So A pledge is a slightly different. You have a definition of the Contract Act as well, and that's what differentiates the charge and the pledge. Now, lien is a little bit interesting in the sense it is when I forward you a movable good, so the possession is also with you like a pledge, but it's for a specific purpose. So let's say I gave you my furniture to repair, and I do not pay you back your or I do not pay you for the services in the repair of the furniture. Therefore, by operation of common law, you can claim lien over my furniture till I pay you the money. So I gave you the goods for a certain purpose. The purpose was achieved. However, I did not hold my end of the bargain. You can claim a common law right of lien over my goods. So again, these are different kinds of security interests. So if you have conceptual clarity as to how these things are, you can see that these concepts are worded differently in different paperwork and different documents. But essentially, it all remains about who has ownership, who has possession, and which end of the spectrum you lie on. If you have that clarity, it's really helpful before we dive in, and just generally under bankruptcy law. Now, some other concepts which you find often are subrogation and guarantee. These are fairly simple on the face of it. However, once you start dwelling into it, it becomes more and more complicated. Subrogation is in insurance contracts, we fairly see doctrines of subrogation, where the insurer will step into the insured's positions and then claim for damages or remedies on his behalf. So these are also kind of contractual rights we see very often. And personal guarantee is also a current hot favorite on the NCLT right now. When individuals give personal guarantee for corporate loans, and what is the treatment that should be meted out to them. So guarantee is also a concept which is kind of very readily uh, looked into. Now, these are some further readings in case everyone's more interested in knowing what the interim report of the bankruptcy law bit of the reform committee said, or what the UNCINTRA legislative guide is. These are kind of, they laid the groundwork for the insolvency and bankruptcy code. So these are interesting. And then there's a couple of articles. One was which was written by Aparna Ravi and about with Rajeshwari Sen Gupta about the Sarfazi and the RDDBA and their failures. So these are interesting if anyone has an academic interest and would like to look at that. Okay. Now, coming straight right into the insolvency and bankruptcy and the process which it entails. Now, since I was asked to kind of simplify it and really make it very easy and hard, I basically came up with basic diagrams which kind of show you a rough way in the manner in which we are running the insolvency resolution process currently in our country. So the way we are doing it is that we divide the different actors involved in the running of a company, and then we give them names. We give them names which we make for them. Don't ever tell a businessman that that's how you run a company. Don't ever, because he will just look at you bewildered. But for the purposes of the court, we classify our actors into operational creditors and financial creditors. Now, what you see in the middle is the CD. Now, a CD is an abbreviation that I've used. It's essentially short for corporate debtor or the company. So essentially, a company is the middle circle that you're seeing. The little pink that you see in the middle here, that's the promoter. Now, I'm aware that a promoter is a separate legal personality from the company, and I should not be showing it in kind of overlapping Venn diagrams. But since this is only a rough estimation of how a company runs, I decided to take artistic liberties with the same. Now, in terms of operational, so the code looks at a company, a corporate debtor. It looks at as a financial creditor, it looks as an operational creditor. And then all these creditors provide the different inputs into the company. The company, let's say this is a manufacturing company. It manufactures the product and then delivers it to the customer or the end user. Now let's look at each of these heads separately. A financial creditor is one of the most important agents in any company. Essentially, a financial creditor is a bank. It can be a financial institution. It can be an NBFC. There is a proper definition clause which the IBC provides for. Essentially, anyone who's giving you money with and who's charging you an interest over a spread period of time. So anyone who's basically charging interest, who's providing you money interest over a period of time is a financial creditor, essentially. So you read the loan agreements, term agreements, working capital agreements, any kind of credit agreement that you see is essentially a financial creditor. Operational creditor is a little more flexible in the sense of it's a more wide definition. Any supplier which provides you with raw material is an operational creditor. So anyone which actually gives you money, I'm sorry, anyone that actually gives you a raw material, let's say if I'm producing, let's say, a machine, so providing me with, let's say, the pulp of the paper.
Hi, Shivankar, sorry to interrupt. I guess your voice is cracking. Can you just check your internet connection or?
Is that better?
Yes, now it's better.
Can I continue?
Yes.
Okay. Now, any kind of vendor, essentially a supplier, is your operational creditor. He's not actually giving you money. He's providing you either a product or, let's say, he is taking care of your customers on your behalf. So he's running a call center. So he's providing you a service. So anyone who's giving you either a good or a service for a money's worth is an operational creditor. Second in the list is a government entity. So any license that you have, any permission that you receive from the government, or any GST authority, any input tax credit that you have to pay, any VAT, excise duty, customs, just about anyone. That's the middle part. It's fairly simple. It's the mandate or the permission from the government to run a company. Now, the third and the most important, which I find is increasingly taking a big turn in the sense that they're commanding a lot of attention in the market today, are the employees and workmen. The code actually differentiates between the two. The employees are actually the white collar workers, and the workmen are people who are defined so and who actually work. Your Industrial Disputes Act and your other acts also define workmen. So does the code, but a workman is essentially a blue collared worker. It's a rough distinction, not necessarily 100% accurate, but for our purposes will suffice. Now, a CIRP can be started by either of these sides. It can be started by an operational creditor, it can be started by a financial creditor, or it can be started by the corporate debtor itself. So think of it as an implosion. So either you can be hit from the right side, you can be hit from the left side, or you can kind of implode into your own self. Now, this needs to happen at the forum at which this happens. The forum at which an operational creditor or a financial creditor will go is the NCLT, the National Company Law Tribunal. There are about 11 in different cities all over the country. And you need to make an application. More on that later. It's a stat standard. You kind of put in the application, the court hears you out, and then provided you have a default. Now, the important word is default here. That's what innuendo, Swiss ribbons, and a lot of other Supreme Court judgments refer to. Provided there is a default and the court has seen from the record or from the information utility, there is a default, they will admit you. Now, this arrow that you see as Section 14 moratorium is a one-way stage. Think of it as kind of entering in to the deep end of the pool. Once you are in the swimming pool, you have to kind of cross over to the other side. There is no going back. There is, of course, one kind of exception to this rule, but once a moratorium is imposed by the order of the court, then there is no heading back. Now, what exactly is a moratorium? A moratorium is essentially, think of it as a freezing order. So once the court kind of takes you into its perspective and jurisdiction, everything freezes. If there is any pending litigation against you, they will freeze. If you want to alienate your property and kind of sell it off, in the earlier acts, you could do that under Sarfazi. So I'm sorry, under RDDP or under SICA, you could kind of erode your company. You could kind of sell off your company from the side. None of this is possible because within 15 days, you move an application, a court needs to decide whether it's got merit. If it has merit on the event of a default, Section 14 moratorium is imposed, and boom, you are in this cycle, and everything freezes. You can't touch the assets of the company, you can't erode it, and it's very difficult. And as to how it happens is that the promoters, the pink bubble you see on the left, is actually out of the company. So your existing management is no longer in control of the company. Your RP, which is your resolution professional, more on that later as to what this RP is. It's a creature, or it's a creation of the statute, and what exactly he does. But essentially, there is a new management which comes in. He is a specialized expert. He's either a lawyer with 10 years experience. He's either a chartered accountant with another 10 years, or a cost accountant. So here's a guy with with some experience and some idea of the law and finance on his side. He comes in and takes over your company. So think of it as a hostile takeover, except that there is no shares involved, and you kind of fail to pay your debts, which is why a new guy came in. Now there are different thresholds under the act. He needs to make a public announcement. The RP will inform the general public that the existing management has been done away with and the company is in insolvency. He will prepare an information memorandum, which essentially means he will prepare the list of the OCs and the FCs, the operational and the financial creditors that I referred to earlier. He will come out with an expression of interest where he will call in new. More on that later. Let's deal with that later. Parallelly, he will set up a body called the Committee of Creditors, or the COC. Now, the COC is a very interesting body, again, a creation of the statute. It's essentially all your financial creditors sitting in a room and deciding what to do with the company. It's not your operational creditors, provided you don't meet the 10% threshold criteria. It's only your financial creditors. So you can have a situation where a process was initiated by the OC, but ultimately it will be handled by the FC. Essentially, your financial creditor is always in the driver's seat, and the person to do its job is the resolution professional. Now, the third stage in an insolvency proceeding is that we are now running the company. The company is being run. The RP is in the driver's seat. He's communicating between the COC, and he's kind of handling the management, the company. He's talking to the employees. He's making sure the crucial supply agreements are still there, that the licenses subsist, that the payments of rent happens, that people get their salary. So he's running this added responsibility for which he's obviously getting paid. He's not doing it for free. But in the meantime, he's also running the process. So he's also telling the public that, listen, here's a company that's currently under my charge. If you want to take over, and if you're in a similar industry, please send me your application, and then we'll have a vote about it. So the way the RP goes about doing it is by preparing an information memorandum, by having an evaluation matrix, by preparing, by apprising the COC of the steps taken, and then you have a stage where you keep a window open. And different people apply. So, for example, if you may have seen, Bhushan Steel is a good example. So, Tata Steel made a bid for Bhushan Steel. So, if Bhushan Steel is the corporate debtor right here in the middle, Tata Steel was this new entity which is in pink. Now, we have new actor here. It's called the RA, which is a resolution applicant. So, I am a prospective bidder. I like the company. I like Bhushan Steel. We're in the same business, and I think we'd make a good synergy. So, I approach the COC with what we call as a resolution plan. I say, okay, here, creditors, hear me out. Here's kind of how I will pay you back. I will obviously not pay you the full amount. So you'll have to take a haircut, and you will get 10%, you will get 5%, and you then give me the company. So let me take over the company. So once this resolution plan is voted by the COC by 66% vote share, earlier it was 75%, it then goes to the NCLT. So the RP then, after COC approval of the resolution plan, then takes it to the NCLT. The NCLT puts a stamp of approval, and the moratorium that we discussed earlier then comes to an end. On the left side, if you will see, now the RA is in charge of running the company. The RA is in charge of the CD, and the RP is still outside. He's still not disappeared because the RP has more work to do. The RP will file certain applications. I will deal with these later, not necessarily not important to get into details of what those applications are, but certain transactions can be set aside within 150 days from the CRP admission date. So that's on the left side. However, if this grand scheme of things, if this plan fails, or if the RP is not able to, if the RA is not able to make a convincing case to take over the company heads in a liquidation. Now, liquidation is one in which the assets of a company are stripped down, and then they're divided amongst the different bodies. this is kind of the section 53 waterfall. So first is the CIRP cost, most important. RP's payments need to be released. He needs to get its money. And then there are different kind of layers to it. You have the dues of workmen, you have the secured creditors, and then a similar kind of waterfall as to what was there in the earlier act. Okay, in the end, you will see come as you, if you're aware of your company's act knowledge, the preference and the equity shareholders, because the shareholders are always the last to be paid. So first layer of payment will go to the CIRP cost. Second layer of payment will go to your creditors and your employees. And the third layer will come to your shareholders at the end. You can look at this in detail. It's provided under section 53. Now, what exactly is a resolution plan? What I was referring to over here on the first slide over here, the resolution plan. This is a classic example of what is contained in resolution plan. So a resolution plan will say, okay, IRP costs is, let's say, 18 lakhs. I will pay you 18 lakhs. Secured financial creditor, X bank. It has, the verified claims. Now, these claims have been verified by the RP earlier. As to how he does it is another procedure. No need to get into it in detail. But he has about 41 crores here, but he's only getting, if you see, a proposed settlement of 9 crores. So the bank X had an outstanding payment of 41 crores, from which the new management or the new RA is only offering him 10 crores. And he's gone ahead and still passed this plan, because otherwise this is a dead weight for him. He possibly cannot do anything with the company, right? He will have to write down his 41 crores. So it's better than that to take the 10 crores and exit. So different other heads that you see are unsecured financial creditors. Those are related parties. So obviously any company which is related to the corporate debtor, it's kind of a hard argument to pay them anything, because you're a related party. You knew what you were getting into, and there are ethical reasons why you shouldn't be getting money. Operational creditors under OCs, you will see the suppliers, employees and workmen, priority dues, then 12, 24, gratuity. Now, gratuity and provident funds are becoming increasingly important in litigation before the NCLT, because the employees and workmen are increasingly demanding full share, because the way they look at it, provident fund is a share which was indeed owed to them by the company. The company made certain deductions, and at the stage of resolution, it becomes very heartbreaking for them to take a haircut on their provident fund, which the company has to pay. A lot of times, obviously, this is not paid, or it's paid not in full. So there's a lot of increasing litigation that I find before the NCLT courts, which are happening from the employees and workmen sides. And then those is followed by statutory dues, which are basically your government dues: excise, service tax, TDS, and then PF and ESI, as I mentioned to you earlier. If you see the last in this, it's the payment to shareholders. So the verified claim is of 20 lakhs, for which they're getting 100%. So they're getting, I'm sorry, not even 20 lakhs. I think it's 20 lakhs. Yeah. So they're getting 20 lakhs. And so the total verified claims out of 68 crores, only 10 crores are being paid. So that's your atypical resolution plan, which you will find in a resolution applicant's book. Okay. Now, the Insolvency and Bankruptcy Code, I've briefly explained to you how it runs, as to what are the different kind of actors involved. But it survived a constitutional challenge, which is a true measure of a legislation in our country. There's always that one constitutional challenge that you have to survive, and that's how you become a surviving legislation. It's a survivor. It's beaten that one guy who filed that in Supreme Court. That's a very good judgment. Swiss ribbons. I would highly urge you to kind of go through it in detail. It's very well written. uh, Feynman sir has written that judgment. It's very well detailed. Now, the regulatory structure is primarily the IBC makes certain new bodies. The resolution professional was one that I explained to you earlier, but more importantly is IBBI, which is the Insolvency and Bankruptcy Board of India. Now, this is both a regulator as well as a process. It's a regulator of the profession of RPs, and it also regulates the process of CIRPs. Now, what do I mean by that? Now, IBBI is, think of it in terms of SEBI. It's how SEBI or SEBI regulates mutual funds, and how SEBI regulates other kind of funds. In a similar way, your Insolvency Board of India regulates the profession of resolution professionals and registered valuers and other kind of bodies which are involved in this process. At the same time, it also comes out with these regulations, which kind of detailed as to how the process will take place, how the voting will happen, how the COC will decide, who should be given audience to, who should be not heard, what should contain in a plan. So these are all detailed in a regulation. It's all listed on the RBI website. It's a very good website. You should probably give it a time if you have some time. You also have certain rules that the executive has come up with, application to adjudicating authority rules. Again, these list out in which forms do you make filings before the NCLT, how do you do it in Form 1, in Form 3, in Form 5, and it's more procedural in nature. Now, we've already dealt with the initiation of CIRP by a financial creditor, an operational creditor, and a corporate debtor. Just a quick word about the law of limitation. Now, as you know, that the act came about in 2016. Now, what happened in 2016 was that no one was quite sure what limitation applies in the Insolvency and Bankruptcy Code, because the code was as such silent on any limitation aspect. This was a grave cause of concern. And there was a certain amendment which happened in 2018, pursuant to which Section 433 of the Companies Act was amended, and it said that any proceeding before the NCLT will be governed by the Limitation Act. Okay, fair enough. We have some visibility now. At least we know the Limitation Act will apply. But the problem still remains as to what entry of the Act will apply and what happens to all the cases between the Act coming into force and the amendment coming into force. Specifically between 1/12/2016 to 6/6/2018, what happens to the filings, or what happens to the cases which have been filed by the FCs and the OCs then? That was kind of the question on the mind of the Supreme Court, and it was answered in the case of BK Education Services. It's a landmark decision. Anyway, it's also a very well written decision, and it was argued that rather the court held that Limitation Act is retrospective in its application. So even if you can say that it came into fruition only in 6/6/2018, but the look back period very well survives from the enactment of the Act, because law of limitation is a domain of procedure, and procedure can very well be retrospective, because IBC cannot revive any dead claims. So if you are a financial creditor who gave a loan way back in 1991, which became due in 1995, you can't come and say in 2016 you must pay me back my money because I can only enforce my right in 2016. Your claim or your limitation started running in 1995, and for you to now come to me after 20 odd years and say that you must pay me back the money, that can't be the intent of the legislature, and which is what the Supreme Court discussed in great detail, where it referred to the Insolvency Law Committee report which led to the amendment. It also discussed what exactly is a debt, when it becomes due, and when it becomes due and when there is a default in fact and in law. Now, it's only when there is a default that happens can you say a debt is due. Now, what exactly is a default? Now, default, there is no standard definition under the Act. A default needs to be adjudged from a case-to-case basis depending on the contract in question. Now, which is why I find that contractual concepts such as the ones I was referring to earlier will come in very handy, because every bank will advance you money based on its specific contract, and every contract will have certain defaults or when money becomes due and when it can force its security. Now, it's on that day does your limitation start, and not on the day when the code was passed or when you actually file in court. So a limitation needs to be measured from your default date and not when your debt is due or not when the filing is made. It's a very good judgment. I again urge you to read it if you have some time. BK Educational Services speaks about a lot of things. It was Mr. Ashish Dholakia tried to convince the court very convincingly that law of limitation does not apply to tribunals, that you can't have this concept, that the IBC is a complete code in itself, and Justice Nariman was very convincing in his argument, where he said that that's not the case and things can be looked at separately. Okay, now what are the defenses available to the corporate debtors? Now, what are the defenses which are available to the corporate debtors? Now, if you are a company and if you want to kind of stop that Section 14 moratorium from happening, so you want to nip it at the bud, you have a very limited set of actually defenses you can claim. So first defense is obviously very simple, that I didn't have any financial debt. that the creditor or the person who advanced with the money is obviously fabricating its documents. There is no default. The claim was disputed. However, under Section 7, uh, the disputed the even if if financial debt is disputed, if the court is convinced that a default has occurred, then it will admit a company in CIRP. It is so you need to kind of make a very strong convincing case that there is no default that happened. So a financial debt, if it's there, you should make a very strong case for saying a default has not happened. And even if the money was due, it was not payable because of limitation, because of some fact. Innovator Industries is a Supreme Court judgment which deals with this in great detail. The defense is available to a corporate debtor against a financial creditor. Now, operational creditors, things are a lot more interesting. There's a lot more kind of artistic imagination which the law gives you, because here on the left side, if any of these guys comes and kind of asks and kind of makes a petition to the court, and the law provides you under Section 8 two steps. So first of all, they can't go to the NCLT directly. An operational creditor first must send you a notice. So you must receive a legal notice in Form 3 or Form 4, which says that, okay, you need to pay me money. So if I'm a company and if you are my vendor, you will send me a notice first, to which I will respond and tell you, okay, actually, you know what, there is a fight between us. We are actually litigating in Delhi High Court, or there is an arbitration between us, which is happening pursuant to this private tribunal. So, I actually don't, that money is disputed. In this case, the law is okay with the dispute. So dispute is all right. Pre-existing dispute is totally fine. And then you can't not allowed to go to the NCLT because your amount has never been crystallized. See, the point is that the amount needs to be crystallized and there needs to be a default. So if I can prove that there is no crystallization or there's no default on that amount, the point is that I don't owe you the money. There is a very interesting case, Mobilox, by the Supreme Court on this. Now, a couple of you, for all you may be interested, your TV buffs, Nach Baliye was a show which was doing great rounds. I think it was being played on Star TV. And so Nach Baliye, you had voting options. The facts of the case are that you had certain voting options that could be exercised by the general public. Now, what happened was that the general public used to kind of vote for the favorite contestant, and then he went ahead and won the show. So the company which was in charge of all these voting operations and collating and collecting these votes, it outsourced its operations to a subcontractor. Now, but at the point of outsourcing, it entered into a non-disclosure agreement saying, okay, you can't disclose existence of this to anyone else outside. So they said, all right, okay, we won't do that. So then they raised certain bills. At the same time of raising the bills on their own website, after they signed an NDA, they went ahead and they wrote that we are the proud kind of subcontractors for the Nach Baliye hit TV show. And then, we have done such great work. Everyone loves us. We are the biggest thing that happened to the Bollywood industry. Now, Star was aghast because they said that we asked you to sign an NDA. The whole point was that you don't have to disclose it. And then you are saying that on your website. On top of that, then you're sending us an invoice saying you haven't paid us your money. Please, this is a clear dispute. We are not paying you anything. Pursuant to all of this happening, they actually went to NCLT Bombay and then raised this saying, these are the invoices which are due. Star is not paying us, so could you please look into it? And the Supreme Court, this case went all the way to Supreme Court. It held that, Star hadn't given you adequate notice that there is a dispute about the NDA. The amounts which you're claiming were not undisputed in that sense. So there was very much an existence of a dispute. Now, the argument which was made from the side of the subcontractor was that, see, the language which is used in the statute is existence of a dispute and a pending suit or arbitration. So even though there may have been a dispute between the bodies, but the fact remains there was no pending suit or arbitration. The Supreme Court said fair enough, and they read that and they watered it down to read an or. So, and there was also an amendment which happened in the IBC thereafter. So it became the existence of the existence of a dispute or a pending suit or arbitration. So very interesting kind of constitutional powers of the court and how they kind of read down the act itself. So interesting case for those who are interested. So pre-existing dispute is one, and money is time barred. I've dealt with this one, that the law of limitation applies. Now, some of the actors in the CIP process are the erstwhile promoters and management, which are the ex-directors, which is best represented by our lonely friends over here, the which is in the pink. So the old guys essentially. Now the interim and the financial resolution professional, I've already said that the resolution professional is an interim resolution professional till his appointment is finalized by the COC. So this person is the most important person under the code. He runs the whole CIRP process. He has a lot of tasks under the process. So he does a very important job, the way I view it. Then there are registered valuers whose job is to come out with liquidation value or the fair value. Now these are concepts which the code uses. Liquidation value is nothing but the value of a company it was liquidated on the day of the CRP admission. Fair value is the amount the company will get in a normal day-to-day kind of between buyer and seller at arm's distance. Then you have process advisors, which are essentially your big four law firms. You have transaction auditors. Uh, this is a little complicated. These are for fraudulent transactions. You don't need to know this in detail. Of course, and there are lawyers, which is us. We come in handy in a couple of locations. We advise the resolution professionals about how to do their jobs better, or do it more efficiently. We also advise other transaction advisors. We are the interface between the different actors and the NCLT, so we come in over there. Now under operational creditors, I've already explained the employees, the workmen, and the government authorities. Now the committee of creditors, which essentially is the body of financial creditors, which all then votes according to the voting share. The resolution applicant, which I told you is a new kind of guy who makes a bid for a company, and then the shareholders. Actually, shareholders are probably, they got the shortest end of the stick in the CIP process. I've very rarely kind of come across any shareholders getting practically anything, mostly because they coincide with the promoter and management, which is the first category, but otherwise so as well. Now, Swiss ribbons held, and this has been a constant theme under the CRP, under different forums, it is that the process is that of resolution and not a recovery mechanism. So even though a lot of firms would like to use this as a recovery mechanism, it's essentially a resolution process. The point is the trigger may be a default, but the actual process is for resolution of a company. You want to keep the company going alive. You don't want the company to be eroded. You don't want the company to be rusted. You do not want the old management to erode and kind of sell away the properties of the company. So you want to preserve it because the best possible person should come in charge and then run the company. The old guy clearly did a terrible job. So we invite the best possible guy to come and kind of run the company. The act itself has gone 3 amendments. It was passed in 16, one in 17, 18, and the last in August of 19. Pursuant to SR Steel and kind of when they redid the whole amount which the operational creditor should get. So it's a little complicated like that in the sense of we always take retrospective actions, but that's nothing new about insolvency. Indeed, it's true of all Indian legislations. Stages in CIP process, I've anyways explained earlier. There's section 14 moratorium, which is basically the freeze order. Section 12 is withdrawal. So there is a limited, I did when I was talking about moratorium, I said it's irreversible, but that wasn't fully correct. There is one exception. You can get out of the CIP process provided 90% of the creditors agree. It's a very high threshold. Now you will ask me why 90%? If only one guy has started the CIP process, why must all of them agree? Because it's an in rem proceeding. The Supreme Court also discusses this because it's a proceeding against the world, and everyone's shares must be kind of negotiated. You can't basically say that मैंने उसको पटा लिया या उसकी setting हो गई है मेरी, so I'm going to just cut now. So it's very easy for that to happen. And so 90% approval is required. Committee of creditors, anyways, I've dealt with approval of resolution plan and liquidation. Now, liquidation is probably another set of slides. I don't want to get into this stage, but it's quite important going forward. A lot of companies are not able to not all companies are recovered. Some of them are lost to liquidation. So the end result is either you make a recovery or you liquidate the company. Now, constantly throughout insolvency, there is this tension between operational creditors and financial creditors. It's been there for the past 3 years. Finally, it was settled in the favor of financial creditors pursuant to the SR Steel judgment in 2019. Essentially, financial creditors are the smart guys. They have the business acumen. They have the feasibility and viability of any resolution plan. They have the numbers before them. So they are the best suited as per the BLRC and as per the Supreme Court to take a call as to who should take over the company. The operational creditors have a very less say over there. You may be a big supplier, you may be a big customer, you may be a government authority, but for the purposes of the insolvency committee, you are essentially, you're a small guy. It's financial creditors who run the basic show. Now, I want you to just mention here winding up proceedings under the IBC and CA. Now, I don't want to get into detail about this, but you should know that companies can be wound up outside of IBC under the Companies Act as well. If the registrar thinks there is a fraudulent purpose, or if you are doing kind of some fraud, or if the company decides to wind themselves up. So this is not the only way to wind a company, liquidation. You can also have separate winding up proceedings under the Companies Act, which still survive and which take place before the NCLT, but under the Companies Act, or not the Insolvency and Bankruptcy Code. Certain grounds for appeal before the NCLAT and Supreme Court. Any order of the NCLT which is passed is appealable to the NCLAT. The time limits are 30 days within receipt of certified copy, within receipt of order, sorry, and 15 days condonation delay. Similar timeline for Supreme Court. So it's NCLT, NCLAT, and Supreme Court. Again, I'd find pertinent to mention here about the undervalue, fraudulent, extortionate, and preferential transactions. These are the ones I was referring to over here. Don't want to get into this in detail considering it's only a basic class, but certain transactions can be set aside by the NCLT at a later date. Now, the last thing I want to speak about is disciplinary actions by IBBI against resolution professionals. You see, RPs are not always kind of, it's a very gray zone in which they operate all the time. It's not very easy for them to kind of say, okay, this is the way it should be done. So a lot of IBBI as a regulatory body also institutes its own disciplinary actions against the RPs. If you would have read in the news recently, I think it was about last year, when one of the biggest law firms in the country in Delhi was asked to pay 12 crores, which they got as the lender's counsel's fee under the CIRP cost incorrectly as per the IBBI. So it was a big order that was passed for a very big law firm to be told to kind of reimburse the 12 crores back to the corporate debtor, which was paid by it incorrectly, or which was not paid by it in the correct form and manner, rather, not incorrectly. It was obviously appealed and kind of challenged in the High Court, and I think they've given them a stay. But IBBI is quick to kind of act on its body. It's a new body. Dr. MS Sahu is the one who's running it. He's a technocrat. He's a bureaucrat, and he's taking a very. It's almost refreshing for some of us to kind of see a body take such proactive stance. But yeah, it's doing that. So okay, so these are a couple of quotes from Swiss era. I think this is the point. I just want to kind of say that John quotes landed over here, and then I just really want to touch upon how I see this insolvency code develop and how I see this kind of unfold. You see, this was an economic experiment, as the court, as Justice Nariman also describes of it, and the court has taken a very hands-off approach. So this is kind of the quote from Swiss Ribbon, where it says that in complex economic matters, every decision is necessarily empiric and it is based on experimentation, or what may be called trial or error methods. Therefore, its validity cannot be tested on rigid prior considerations or on the application of any straitjacket formula. So the court has taken a very hands-off approach to this, and they have let the law run its own course in that sense. And it's a very unique thing, because otherwise we have a very activist Supreme Court, which kind of comes in usually very strongly and minces no words. But in IBC, in Pioneer Urban, which is a real estate matter, in Swiss Ribbons, in Inventive Industries, in ArcelorMittal, they've taken a very hands-off approach, which is an interesting kind of development from at least the Supreme Court side. Just the last slide, and I just want to speak about the way we can see the law develop going forward. Now, if anyone's interested in kind of in this field as such, there's a lot of normative legal theory you can play around with, because essentially it's an economic law, and there is kind of overlapping of interdisciplinary finance, macroeconomic fundas along with law as such. So it's not just how we regulate these matters, but questions of how we ought to regulate these matters. Now, these are questions which keep me up late at night. You know, the ones that kind of stop me from going to sleep. And the way I look at it is that, imagine if we had to kind of put in game theory, because there are so many kind of actors involved in this whole process. and how would we kind of reconcile operational creditor and financial creditor kind of war in game theory. You see, because what we know from economic analysis of game theory is that coordination always results in a net result which is positive. So as opposed to the financial creditor saying I deserve more, or the OC saying I deserve more, if they both were to coordinate, the net sum of the gain will actually be higher than if one of them kind of takes a higher, a more aggressive stand. Coase theorem is again given by Ronald Coase, where he speaks about transactional costs. So you see, IBC is nothing but a transactional cost between bargaining parties. You have the committee of creditors on one side, you have the RA on the other side, and you have kind of the whole transaction between and happening via the forum of NCLT. So questions of how you can incorporate those are also kind of important questions. I'm not able to go into this in great detail, but surely I'm just leaving it out there for anyone who's more interested to read upon them. Again, the questions of prices and sanctions, and Robert Scooter, he was again given the Nobel. I'm not sure if he was given the Nobel for this, but I know the Coase theorem was definitely given the Nobel in 1991. So Robert Scooter says that how every action of the law has a certain price to it. So for example, damages in a contract. So if you and I contract to do a certain act and there is a liquidated damages clause, and if I were to break that contract and pay you the liquidated damages, will that liquidated damages be in the nature of a price or a sanction? In the sense, is that the price I have to pay for breaking the contract, or is that the sanction which the state is penalizing me for not upholding the contract? Again, this comes in handy when we think of this whole divide as to which spectrum will the insolvency and bankruptcy fall in. It's also interesting to do a comparison with the US and UK models. The US follows a more creditor-driven model, which we have now adopted pursuant to the Insolvency Committee, Insolvency and Bankruptcy Code. UK model is what we kind of experimented with earlier in 1980s and 2003. Not much success over there, but interesting to do any kind of academic work and see what the comparison may be. And these are three kind of cases which can be in terms of the procedure involved. I'd like to just mention here the pioneer urban structure case, which is the real estate case as it's commonly called, whereby allottees of real estate projects were classified as financial creditors. Now, this is a case I do not, or this is the or a conclusion or an end result that I do not personally agree with. It is very hard for me to say as to how, if you have applied to get a house in a housing complex, how you can be classified as a financial creditor and not an operational creditor, if at all you are a creditor. It's a deeming fiction. So again, some work to be done there for any student who is interested in kind of looking at this as to how you can have a deeming provision wherein some bodies are financial creditors. So just interesting to maybe read this case. This is Ronald Coase and Robert Scooter's articles I was referring to. Now, as to how all this happens in practice, so NCLT, like I said, are in 11 cities in the country. Know where the NCLT University is located. As to how you can put all this knowledge in practice, NCLT is in the CGO complex in Delhi, and NCLAT is in MTNL building, and it's also recently established a bench in Chennai in March. So we have 2 NCLATs in the country as of date. A munshi is a good friend. You should ideally befriend any munshi you find in NCLAT, because these are people who have very good they're very well conversed with filings and what is the best way of the procedure which NCLAT is following. Cause lists is very important because sometimes your case is either coming up for in supplementary, which is fresh cases, or it's coming up for orders. So knowing as to how cause list of NCLT operates is also a good practical advice that I can ask you to be aware of. The NCLT and NCLAT websites are also kind of a resource for existing orders, so you should know your way around those. NCLT rules, again, by fairly self-explanatory, but some of the important rules. Court fees, yes, your court fees, this is your checks, whose names are your check drawn in, pay and account officers, Ministry of Corporate Affairs, very important. You have to cure the defects which are raised by the registry in 7 days. Again, a very important threshold for a junior lawyer, because you only get a 7-day window. Obviously, it's I'm forgetting the case, but the Supreme Court has held it's actually not mandatory. It's not fixed. 7 days is actually flexible, but it's better to cure it in 7 days. board resolutions, tying up with your Companies Act. Any person who signs a wakalatnama on behalf of a corporate debtor or a financial creditor needs to be certified by the board. So board resolution is a must, and a couple of other housekeeping rules about eligible copy, translated copies, and serving. Just the last thing that I want to deal with here is that very often in terms of monetary matters, the temptation to kind of take your client's side is very high. So a client will say, okay, why don't you write, a larger amount, or why don't you claim a little more, or why don't you do that? But it's very important for us to be realized here that we are all officers of the court, and it's very unethical for small kind of wins for us to kind of embark on all these small tinkerings about, because there's a lot of ethical kind of considerations that I personally find myself with dealing with very often in the court. But yeah, just food for thought that we are officers of the court, and although interest of client is of paramount importance, but that shouldn't give us a window to kind of compromise on ethics. A couple of other things that I found interesting, which maybe interest some other people. We have, I think IBBI has engagement of research associates. They have a couple of regulations. So if you want to kind of be one of the 50 people, you can probably look at doing a research associate position there for some time. It's very helpful for someone who is interested in these matters, who wants to apply for their LLM. So very kind of useful to kind of do a 1 or 2 year stint over there. And just the last point on a lighter note, that this is kind of a chamber etiquette that was doing rounds on the internet. And I would like to just draw your attention to rule number 9 over here. So just goes on to prove what a constant, this flux the law is, and so many amendments that come our way. But yeah, I'll be happy to take any questions or anything.
Shivankar, just go to Q&A section on the window below, next to share screen.
Okay, we have some questions here. Okay, so first question: do you think post-economic recession due to coronavirus pandemic there'll be an impact on the legal field, given that insolvency practice might? Okay, I'll just read this slowly. Do you think post-economic recession there'll be impact on the field, the legal field, because the insolvency practice might increase for law firms, or will there be positive or negative insights on recruitments? This is obviously a concerned law student who is thinking about his chances. Honestly, Section 4 has been amended, so the threshold of default of 1 lakh is actually being increased to 1 crores. So if you ask me, because of coronavirus, action of NCLT is on hold, and it's somewhat decreased right now. So I wouldn't say that it's on the up and up. And as far as recruitment and law firm question goes, again, I wouldn't say the market is exactly booming. I wouldn't ask you to have no faith in yourself or kind of just give up hope completely. But truth be told, the market is not exactly booming, and I don't foresee it to boom in the near future. Could we have a short discussion on the validity of Section 29A and that whole debate? Section 29A basically lists out which people or which persons are not fit to be eligible resolution applicants. It's highly technical. It has maybe about 20 grounds. I wish I could have entered into it, especially the whole ArcelorMittal case. But this session will definitely fall short. So I'm sorry, Aditya. We can probably take it. We take it up privately some other time. Okay. Could you really talk about the role played by the home buyers in insolvency case filing against the developers? Are there any rules and regulations which govern the manner in which the home buyers may file their application, participate in the CIP process? Yes, there are. So the threshold which exists as of this day is 100 or 1/10 of the total strength, whichever is lesser. So you are a financial creditor. Currently, what is happening under the NCLT is the courts are asking you to meet the threshold in that sense, and they're asking you to refile or kind of at least prove that you have the numerical majority in your favor. So as to the procedure, it remains basically the same. It's as per a financial creditor, you file under Section 7 and you file under Form 3. So it's basically the same as any other FC. And yeah, there are rules and regulations. You can read the Pioneer Urban case for kind of greater clarity on this, Anurag. Does an appeal fall under a pre-existing dispute considering there is no stay against the corporate debtor by the appellate court? It's an interesting question. This is from Abhilaksh. It depends on whether the moratorium is active, I would say, considering, but you're saying pre-existing dispute is one. I would say, yeah, I would tend towards a definite yes, because the fact that you have gone litigation at a lower forum, so even though you might get at an appeal stage for which no stay has been granted, that's actually, Abhilaksh, we'll have to take that offline. It's a very good question. I would tend towards a yes, because there is a dispute about it, and since your right is, and your right is open to kind of appeal about it, or you to kind of take it to the next forum. So there is no finality in that sense. That's a very good question. You got me over there. Does the corporate debtor have any say in the resolution plan submitted by DRA? No, because that's problematic, right? The corporate debtor is to kind of start interfering with the plan which the RA has submitted. Essentially, it happens in practice. We see it happen, but it's ideally, on theory, it's not supposed to take place. Your corporate debtor is kind of outside the purview. You can't even do it because the corporate debtor has no voice. You see, a company has no voice. So who will it voice its concerns under? Are the cases filed by home buyers akin to a class action suits? Look, as of the current, I mean, it's increasingly looking like that, because you are asking them to file under a certain number. So you're asking them to kind of come together as a big group. But since class action suits are not really strictly defined anywhere, it's very hard to say whether there is there is no definition of a class action suit. But in fact, I would say it is very similar to a class action suit. However, the whole concept of class action suit is very open and variable in India. So yeah. Okay. In case of set-off, how do we as individuals owe debt to banks? This is a very ingenious way in which you say that, for example, if I'm a bank and if I give money to an individual or a company, because we're not talking about individuals here, but I disperse, let's say I was supposed to sign the agreement today. I was supposed to disperse the money tomorrow, but I actually give it to them 2 months later. At this point, the individual will say, you owe me interest for the 2 months, which you didn't, or I will not pay you interest for this month, or you kind of, they'll try to get into a penal clause or kind of, reverse claim against me. So that's how a company can kind of raise a claim against the bank, saying you did not disperse the money on time, or even if you did disperse the money of time, it was not the complete amount, for which we have accrued interest, or we have lost further use of money, for which you owe us more money than you originally did. These are very ingenious ways in which very smart lawyers who exist in NCLT come out with even brilliant ways of defeating the claim of banks. So that's one way of, let's say, doing it. Can an application for CIRP be withdrawn after the moratorium has been imposed on the company? Yes. Section 12 and Regulation 30 provide for that, Palak. In what cases can an OC be a part of COC? Shreyashi. So an OC can be a part of COC if they are more than 10% of the financial debt which is owed. That's literally the only way. Otherwise, there is no leeway which has been provided to the OC to be a part of the COC. So very limited in that sense. Shri Pandey, how do you see the practice changing post increase in threshold limit? And do you also think many lawyers will lose work? Yes, that is very much a reality of the times we are living in. A lot of people are facing a very difficult time because of this whole inaction, the situation that we are currently in, the pandemic situation. The threshold, I believe, is a temporary phenomena. I believe it will be kind of restored to its normal levels once the economy is able to take it in its stride and move and bounce back. So the threshold is definitely will be revised, but till that time, some people will suffer. And yeah, it's a part of the macroeconomic way in which we operate. So how can a manager of an RWA file on behalf of homeowners even though he himself may not be a homeowner? You see, the homeowner threshold is actually 100 or 10%, whichever is less. So if a manager of an RWA can get around and kind of get these numbers in, I would say that you do have a case, but as an individual, you cannot file. I'm sorry. After the amendment, that is. Can a promoter ask for changing resolution professionals in case they are unhappy? They wish. No, the promoters are outside the system. They are outside the circle. They cannot ask for anything. The only time they can attend a meeting is also on the plan approval, I believe. The promoters have no say in the resolution professional. With the new threshold being raised to 1 crore, and given the fact that operational creditors cannot bundle their claims like financial creditors can, what remedy would an OC have if an IBC is not an option for, say, 50 lakh claim? Right now, none. You just, because what has also happened is because they've raised the threshold, Lakshya, they've also put in a freeze on limitation. So your limit, this time which is counted from here going onward is not counted for your limitation purpose. So I would suggest for you to sit on your claim, sit tight, do the paperwork, but not file, and possibly kind of once the threshold is decreased back to its normal levels and the limitation clock is resumed, you can think about filing then, because an OC 50 lakhs is a big amount. It's not a small amount. And you should definitely not kind of just write it off for that sense. And the last question is, please share the articles across. Sure, I'll share the slides and you can have a look at it. And yeah. Anyways, guys, this was very enlightening. Rupin, over to you.
Yeah, thank you, Shivankar. It was a great session. I guess a lot of people got a good understanding of IBC, which is usually not taught in college.
All right.
So
Anyways,
if anyone has any more questions, can directly email to Shivankar. He'll share his email ID.
Yeah, my email ID is shiv.nalsar@gmail.com. Just shout out to Aditya and Rupin for kind of taking out time from the daily schedule and organizing these seminars on a regular basis and kind of giving them the audience that it deserves. So thanks a lot, Rupin, and thanks for everyone for tuning in. And
Thank you, Shivankar. Thank you so much.